Okay, let's get right into this. So this was the United States District Court, Central District of California, Western Division, specifically case number CV 16-1629-DFM. Again, CV 16-1629-DFM, memorandum opinion and order, specifically between Jason William Erstad, the plaintiff, and of course Nancy Berryhill, acting commissioner of the Social Security Administration, as the defendant. So it's this individual versus the commissioner of the Social Security Administration. Let's get into this real quick. Jason Jonathan William Erstad appeals from the Social Security Commissioner's final decision denying his application for supplemental security income. For the reasons discussed below, the commissioner's decision is affirmed, and in this matter is dismissed with prejudice. So the main thing is, this is an individual, he's suing the SSA, and it goes through essentially the OIG report where he was being followed and basically hunted by fraud investigators. Okay, let's get into it. Let's have a little fun. Let's figure out what happened. Okay, I haven't read the whole thing yet, so we're going to figure it out as we rock and roll. Keep in mind, I worked all day, so yeah, yada yada. Plaintiff was born in 1992, administrative record 182-191. In January of 2003, he filed an application for SSI. The application was approved, and he began receiving benefits, which they are 1992. After the Social Security Administration began to suspect that the plaintiff was malingering, which means like pretending to be disabled, okay, and so he wouldn't have to work, a cooperative disability investigation unit, a CDI unit, opened an investigation, that's like the secret police on behalf of the SSA, and found that the plaintiff was functioning at a higher level than his allegations. The SSA terminated plaintiff's SSI benefits in August of 2010. Okay, on May 15th, 2012, plaintiff filed a new application for SSI. So 2 years later, he filed a new application. After his application was denied, plaintiff requested a hearing before an administrative law judge. A hearing was held on August 27th, 2013, at which plaintiff was represented by counsel, testified, as did a vocational expert. In a written decision issued August 21st, 2014, the ALJ denied plaintiff's claim for benefits. The ALJ found that the plaintiff had the following severe combination of impairments: asthma, headaches, obesity, a mood disorder, and psychotic features, anxiety, and borderline intellectual functioning. So as of December 29th, 2012, the date plaintiff was in a car accident and injured his left eye. Plaintiff's severe combination of impairments also included corneal staining, hemorrhaging, and retinal detachment. So obviously eye issues that are pretty severe. The ALJ found that the plaintiff retained the residual functional capacity to perform a full range of work at all exertional levels, but with the following non-exertional limitations. He remains able to do work consisting of simple, repetitive tasks, cannot interact with the public, and has only monocular vision with no stereo function and should avoid hazards. Based on the VE's testimony, the ALJ found that the plaintiff could perform jobs that existed in significant numbers in the national economy. He therefore concluded that plaintiff was not disabled. Now, just a side note, because a lot of people aren't thinking about this right now. Just a side note. The whole thing is this. During 2013, 2014, that's when the entire field of Social Security benefits was changing. That's when the golden days, the paydays of Social Security benefits were diving down. So I studied back then what was happening. And remember, I started my firm in 2013. So back then, Social Security was really tightening and not allowing as many people to be found disabled. And that was also during the controversy where Binder and Binder was caught red dotting, all those files, and that there was that huge situation as a result of that, because they were red dotting files and they were like, okay, we're going to red dot this and not send it into the SSA. So as a result of that whole situation, the SSA was really tightening up and not allowing people, not as many, to be found disabled. So the cash cow of the system, getting people found disabled, was dying. I got into it with my own law firm right when it was going to hell. And I worked for other attorneys before it went to hell. Okay, so plaintiff requested review of the ALJ's decision. After considering new evidence submitted by plaintiff, the Appeals Council denied review on January 19th, 2016. This action followed. Okay, so bottom line is, we're now to the federal court land discussion. Plaintiff argues that the ALJ erred in 1, discounting the opinion of his treating psychiatrist, 2, assessing his credibility, joint stipulation at 6. For the reasons discussed below, the court finds the ALJ did not err. Okay, so let's see what happened. Dr. Chiang's opinion. Plaintiff argues that the ALJ erred by according little to no weight to Dr. Chiang's opinion. Applicable law. 3 types of physicians may offer opinions in Social Security cases: those who treated the plaintiff, so they worked with them; those who examined but did not treat the plaintiff, they saw him once, you know what I mean? Or maybe twice, but they didn't do regular treatment; and those who did neither. They just write a review of the medical documentation, give an opinion. Those are medical consultants, okay? A treating physician's opinion is generally entitled to more weight than an examining physician's opinion. That's what the rule used to be in total. They changed it and made it shitty after 2017, which is generally entitled to more weight than a non-examining physician's, which made sense. The rules used to make sense, but then they got rid of them because too many people were being found disabled. Figure that you would give the most weight of opinion to the person seeing the claimant year after year after year, not the person who's seen them once on behalf of the SSA. When a treating or examining physician's opinion is uncontroverted by another doctor, it may be rejected only for clear and convincing reasons. Okay, that was Carmichael v. Commissioner. Where such an opinion is contradicted, the ALJ must provide only specific and legitimate reasons for discounting it. Okay, so here we go. Moreover, the ALJ need not accept the opinion of any physician, including a treating physician, if that opinion is brief, conclusory, and inadequately supported by clinical findings. The weight accorded to a physician's opinion depends on whether it is consistent with the record and accompanied by adequate explanation, the nature and extent of the treatment relationship, and the doctor's specialty, among other things. All right, let me just solidify what you need to know from that. You need to know that there's a battle of experts when you seek disability benefits. If you're going to master's level providers, therapists, if you're going to chiropractors, right? They're doctors, but come on, you know what I mean? Then the bottom line, to be super duper fair, is that you're not really fighting at the level the SSA is. The SSA is sending you to whatever Ivy League school doctors they can, that literally they just send claimants to over and over and over again to be seen, called CEMEs, consultative examination medical appointments, medical experts. And then they also have what are called medical consultants, MCs. Medical consultants review your file as a doctor, as a specialist, and write up essentially a summation of the medical conditions that you're having and whether or not you meet the severity requirements. So if you're just going to master's level providers and you're just going to chiropractors, you're not on their level. Their doctors are higher up in weight of evidence than your doctors are. So you have what's considered to be a battle of the experts, and you got to go get specialists to battle their specialists. And what's important is around every 2 years, you want to switch specialists or get a second opinion that is consistent with your specialist's opinion. It's important. A lot of people don't do it. It's because, they have a hard time finding another specialist, but it is crucial to get consistent specialist notifications, medical diagnostic impressions, and residual functional capacity letters, physician statements. It's crucial. You got 2 of them, it's going to beat their 1 specialist. Okay. All right, good. Relevant facts. Dr. Rosa Colonna, on June 24th, 2010, Dr. Colonna, a psychologist, examined plaintiff at the SSA's request. That's a psychologist. So we got a high-level medical person, okay? Dr. Colonna, that's the person that the SSA, set up to see this person. Dr. Colonna diagnosed mood disorder and borderline intellectual functioning. She concluded the plaintiff would be able to understand, remember, and carry out short, simplistic instructions. What a surprise the SSA doctor found that the claimant was able to build a bridge all on his own. What a surprise, right? He's a mild inability to understand, remember, and carry out detailed instructions. Plaintiff would be able to make simplistic work-related decisions without special supervision. He was socially appropriate and presented with the ability to interact appropriately with supervisors, coworkers, and peers. How the hell would their doctor know all of that in 15 minutes? I don't know. He'd be able to interact with supervisors and build a bridge all on his own. We expect metal welding from this person. And his coworkers and peers, he doesn't need them because he's so talented. It's just, seeing CEs, MEs, the reports over and over and over again, it's just the same flop. It's you know what I mean? It's just the same thing over and over of this person is only mildly limited. Let them go build a bridge. Let them build a bridge that the entire staff of the SSA would travel over. It's just, it's the same thing over and over. And it's just frustrating. It's so frustrating because it's and that's the thing too. It is not a fair system for the impoverished and the homeless. The impoverished and the homeless, they can't get specialists, they can't get doctors. You mostly get master's level providers sometimes and very rarely. So as a result of that, what's happening is, basically they just can't get competitive doctors at the same level to have equivalent evidence. So, the homeless, the poor, they just get totally screwed over when it comes to the battle of the experts with this stuff. Medical consultants on August 1st, 2012, at the SSA's request, psychologist Sonia Adamo reviewed plaintiff's medical record. This is the medical consultant. Okay, so this is the person who didn't see the claimant, but she just reviewed the overall record and then said, "Oh, well, Dr. Colonna, the psychologist that examined the plaintiff, the medical MECE, clearly said that they're not that bad, and I agree with them that they're not that bad." You're starting to see the game, how they play it. They send you to a doctor, and then they have a doctor review it from the same field that says their doctor's right. You get it? You get how the game works now? Cool, you're on board. On August 1st, 2012, at the SSA's request, psychologist Sonia Adamo, a medical consultant, reviewed plaintiff's medical records and rendered an opinion as to his mental limitations. Dr. Adamo opined that plaintiff was moderately limited in his ability to remember and carry out detailed instructions and interact appropriately with the general public. She opined that he was not significantly limited in all other limited functional areas, including the ability to remember and carry out very short and simple instructions, remember work procedures, maintain a schedule, work with others, and make simple decisions. Cool. So he could basically build a bridge. Dr. Adamo wrote that the plaintiff may have some difficulty with recalling detailed instructions. A small bridge. But he is able to complete and remember short, basic instructions and simple tasks. She believed that plaintiff's anxiety and restricted effect may create problems if interacting with the public occupies a large part of his work. If the public occupied a large part of his work, he's able to conform his behaviors to superficial work settings. Okay, there you go. On November 2nd, 2012, Dr. F.L. Williams reviewed plaintiff's medical record and rendered an assessment similar to Dr. Adamo's. Dr. Williams concluded that the plaintiff could perform only non-public, simple, repetitive tasks. There you go. Dr. Chiang, on December 12th, 2013, Dr. Chiang met with the plaintiff for the first time, and he completed an initial medication support service form. In the section of the form for listing chief complaint presented, problem client goals, Dr. Chiang wrote that plaintiff was unable to do a job and disabled for job, and that he had a history of mood swings, hearing voices, and other symptoms. So basically, the doctor on behalf of the claimant said he can't work, he can't do anything, but the SSA has a specialist that they sent him to, and then a medical consultant who reviewed the file and said the specialist on behalf of the SSA was in fact right. Of course, right? You see how it works. You know what I mean? All right. Under the section of the form for listing plaintiff's mental status, Dr. Chiang wrote, stays home, graduated high school, no college, worked at Career Partners 2.5 months, unable to do the job, no job, mood unstable, or mood stable. Although the form is difficult to read, it appears that Dr. Chiang noted that the plaintiff's anxiety was high, he was paranoid, and he heard voices calling his name. Under assessment, Dr. Chiang wrote, patient is disabled for work. He diagnosed a severe generalized anxiety disorder with severe anxiety, panic disorder with panic attacks, once a week, schizophrenia, and chronic paranoia. At the end of the form, Dr. Chiang reiterated, patient is disabled for work and is totally and permanently disabled. Okay, so what happened was he's got a doctor that says he's disabled, total permanent, can't do anything. And then the SSA is a doctor that says he's only mildly impaired, and the medical consultant that agreed and said maybe some moderate impairments, but agreed with, of course, the SSA's other doctor. Of course. Okay. On January 13th, 2014, Dr. Chiang completed the mental impairment questionnaire AR-786. He stated that he first treated plaintiff on December 12, 2013, and he listed the date of most recent exam, leaving the date blank. Dr. Chiang stated that he had seen plaintiff twice and that he would therefore be seeing plaintiff every 2 months. So, wasn't seeing plaintiff as much as we'd like to see, but, still, again, not everybody can afford it. Dr. Chiang listed plaintiff's impairments as schizophrenia, paranoid, and panic disorder. He checked boxes indicating that the plaintiff was irritable, emotionally out of state, and easily distracted. His thinking was illogical, his immediate memory was poor, and his sleep was erratic. Dr. Chiang indicated that plaintiff displayed difficulty thinking or concentrating, agitation, generalization, or persistent anxiety, paranoia, and suspiciousness, persistent irrational fears, recurrent panic attacks, vigilance and scanning, deeply ingrained, maladaptive patterns of behavior, impulsive and damaging behavior, intense and unstable interpersonal relationships, pathological dependence, passivity, and aggressiveness, social withdrawal or isolation, and delusions. So basically, just looked like he checked a lot on the form. That's all I'm going to say there. It's a little bit over the top, but looks like he checked a little bit too much on the form, a little bit too much on the form. Okay, here we go. Dr. Chiang checked boxes indicating that plaintiff had marked limitation, which was defined as symptoms constantly interfering with ability, the highest degree of limitations listed on the form, to perform all 23 listed mental activities, including understanding and carrying out 1 or 2-step instructions, making simple work-related decisions, and asking simple questions or requesting assistance. So basically, Dr. Chiang apparently phoned it in where he did not fill it out with enough reality. It was just like, oh, he's super magically really, really bad. He just, everything's marked. Everything's extreme. Everything's super bad. So the SSA is not going to give a lot of weight to that. They're just not. Okay. We're getting to the part where the DDS or where the OIG does the investigation. All right, let's skip some of this stuff real quick. Blah, blah, blah. Treatment note, yada, yada. Dr. Chiang. Okay, ALJ's findings, discussion. Let's get past all of this. Hold on. Commissioner, Dr. Chiang's findings were inconsistent with progress notes. So basically, they're throwing Dr. Chiang out the window when it comes to his stuff. Hold on. We got to get to the part where they basically hunt down the claimant and follow him around. Hold on. Treatment notes, Pine, Dr. Chiang, no. Second ALJ producer, no. We're still on the doctor. Hold on. We're getting there. Plaintiff's credibility, applicable law, determine. We're getting there. Plaintiff's credibility. We're getting there. Hold on. Okay, so okay, other factors. Let's see what we got. Relevant facts. We found it. Here we go. In an undated disability report, plaintiff stated that he had been unable to work since September 30th, 2011 because of anxiety, psychological issues, a learning disorder, hearing voices, seeing things, an anger problem, depression, and headaches. In July of 2012, function report plaintiff wrote that he lived in a house with family, gave his dogs water and sometimes walked them, and needed his mother to remind him to bathe, care for his hair, and shave because he was forgetful. Plaintiff also needed reminders to take his medication, to go to doctor's appointments. He prepared his own meals, which included oatmeal, TV dinners, sandwiches, and cereal. I don't know why we still call them TV dinners. I feel like that's a little old school. Took the trash out if his legs were okay and did not have a migraine. Plaintiff could drive, and he shopped in stores with his mother or girlfriend 2 or 3 times a month for medication or personal items. Right off the bat, when I see girlfriend, when you have a significant other and you're disabled, usually that's a red blinking light for judges, because they're then going to be asking, well, how are you able to go ahead and get along with this person if you have all these impairments and issues? He could count change, but he could not pay bills or manage a savings or checking account because he was too much for him to handle. His hobbies include model cars, swimming, watching TV, and playing video and computer games. He did not spend time with others, and he went to church a few times a month. If he felt well enough on Sunday, plaintiff needed someone to accompany him when he went to church. Plaintiff reported that he had trouble getting along with others because he argued throughout the day. His conditions affected his ability to walk, hear, climb stairs, remember complete tasks, concentrate, understand, follow directions, get along with others. He could walk a block or two before needing to rest for 5 to 10 minutes. He could pay attention not too long. He did not follow written instructions well because he got confused, yada, yada, yada. Okay, so he goes through this, outlines all of his limitations, etc., etc. When the ALJ asked whether plaintiff had ever sought treatment at an adult clinic, plaintiff testified that he would, but they're all so far away. And that his mother was busy taking care of plaintiff's disabled father and brother and could not drive plaintiff there. When asked whether plaintiff had sought treatment at an adult facility when he had his own car before December 2012 car accident, plaintiff testified that he had not because he wasn't on Social Security, because he wasn't on the Social Security thing and was just trying to work, and it was very stressful and uncomfortable for him to drive to a different clinic. Plaintiff testified that he had abscesses on his legs that affected his ability to walk, yada, yada, yada. He would lie down for 3 to 4 hours a day, yada, 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 so on and so forth. Obviously, his testimony was very prepped by an attorney. Very, very prepped, okay? Discussion. The ALJ concluded that plaintiff's statements concerning the intensity, persistence, and limiting effects of his symptoms were not credible to the extent that they were inconsistent with his RFC for simple, repetitive, non-public, and non-hazardous work that would be performed with only monocular vision. Let's keep rocking through this. Plaintiff's functioning, yada, yada, yada. All right, let's get through it real quick. All right. Now, here's where we get into where they hunted him down. This is the part where they found him. They hunted him down. They watched him. They sent investigators out to follow him around. This is the part where they basically go through and, they essentially, they chase down a disabled person. Let's get to it. All right, so here we go. Indeed, CDI investigators noted that plaintiff had alleged that he needs reminders to take care of his personal needs, grooming, does not like to go out alone, and rarely drives, and that he has difficulty with memory, completing tasks, concentrating, understanding, following instructions, and getting along with others. But investigators observed plaintiff. So they followed him around, they found him, and they watched him. Investigators observed plaintiff drive with a woman about 5 miles to a strip mall, enter a store, exit about 10 minutes later, and drive away. The shopkeeper in plaintiff's neighborhood reported that a few times a month, plaintiff went to a store in his neighborhood with several individuals about the same age as plaintiff, and that he bought cigarettes and sweets. So essentially what they'll do is they'll go ahead and go ask a lot of the people at the local stores. Usually they'll see the plaintiff going to those stores, and they'll go talk to the shopkeeper and say, hey, can you tell us about this individual? Have you noticed this individual doing things that look like this, or this? Can you kind of explain to me, essentially what's going on? Is this person truly disabled? What, are they able to do these functions? Yada, yada, yada. They'll go through how disabled questions for, shopkeepers, local county people, neighbors, etc. Okay. So plaintiff went to a store in his neighborhood with several individuals about the same age as plaintiff, and that he bought cigarettes and sweets. A neighbor told investigators that a plaintiff drove and cleaned a vehicle, cleaned the yard, and carried objects outside his residence. So basically they're saying, hey, he might be cleaning, notice how they said plaintiff drove and cleaned a vehicle, cleaned the yard, and carried objects outside his residence. So a neighbor saw this and then reported the disabled person, saying that, hey, he was earning some buckaroos on the side, helping clean a car, somebody else's yard, etc. Okay. Both the shopkeeper and the neighbor stated that plaintiff did not appear to have any mental or physical impairments. In other words, both the shopkeeper and the neighbor are shitty people. No, I'm just kidding. They threw the person under the bus. Plaintiff told the CDI investigators that he was able to dress, bathe, groom, and feed himself. So basically the CDI investigators caught up with the claimant. They basically, talked with him, and they kind of said, hey, what can you do? Can you do this? Can you do that? Yada, yada, yada. He drove a car unaccompanied, drove himself to school, shopped at various stores, and made purchases with cash, performed some car repairs with assistance, such as replacing the battery and changing the oil. He washed and waxed his car. He performed household chores such as maintaining his bedroom, helped with laundry, and relatives in public. So, so in other words, they had cameras on him. They were following him around. They had cameras, getting information on what he was doing. They spoke with the plaintiff. They spoke with shopkeepers. They spoke with neighbors, etc. Okay, so essentially, they hunted the kid down and did a full investigation. Plaintiff reported that he usually spent his days playing interactive video games, watching television, and listening to music. He handled his own finances, but needed help with some calculations. He could stay home alone and did not require daily care of assistance. The ALJ permissibly relied on the CDI investigators' findings regarding plaintiff's extensive daily activities and lack of mental and physical symptoms to discount plaintiff's credibility. Okay. So, bottom line is that finding that substantial evidence supported ALJ's credibility assessment in part because CDI unit found the plaintiff shopped more frequently than he reported in his disability application, and that his observed demeanor was inconsistent with someone suffering from his claimed impairments. So, put another way, they follow you around and they see how well you interact with people. They see how well you complete the tasks of having to go shop. They do all this stuff to kind of figure out essentially how healthy you actually are. Now, I'm not doing this video to scare you. I'm doing this video to educate you so you can see what the CDI units are doing when they're following you around, when they're kind of hunting you to build their claim. Okay. All right. Next one. All right. So basically, let's see. Okay. Hold on. All right. Second, the ALJ permissibly discounted plaintiffs' alleged limitations because they were not supported by medical evidence. Okay, lots of quotes. The ALJ found that with respect to plaintiff's mental impairments, the longitudinal record shows that he is doing well mentally on medications, and his symptoms have improved despite little consistent mental health treatment from a specialist, Dr. Bailey, who appeared to be just monitoring plaintiff. Indeed, as discussed in Section A3, Dr. Bailey noted that the plaintiff's symptoms improved with medication and that plaintiff no longer suffered from hallucinations. And as also previously discussed, Dr. Blesa Similarly noted that the plaintiff's mental status examination were negative for anxiety, depression, and psychiatric symptoms, and that the plaintiff was oriented in intact memory, normal insight and judgment, and appropriate mood and effect. Indeed, plaintiff himself reported to another doctor that his medication took care of his hallucinations. So what happened was the ALJ relied heavily on the CDI unit, following him around, as a kid. It's a kid talking to shopkeepers, talking to neighbors, probably talking to family members, and essentially discovering that the child or the kid or the whatever you want to call him was not, in fact, as disabled as which he claimed he was in his testimony, that which Dr. Chiang claimed he was as well. So, with that said, what can we learn from this particular claim? What can we learn from Douglas F. McCormick, United States Magistrate Judge? What can we learn from our good friend Jason Jonathan William Ernstad? Well, we can learn this. We know that when it comes to claiming limitations, the SSA could go and take pictures of you and videos of you and talk with people about you, and they could get evidence relatively easily to show how you're not having a bad day, you're having a really good day, your medications are supportive, and boom, they've got evidence to color, to bias your claim before the SSA going forward. Yes, they usually have dual cameras on them. Yes, they record audio. Yes, they meet with people in your neighborhood. Yes, they talk with people to find out what your usual daily activities are. Yes, they talk to shopkeepers because they want to know how often you actually come to the store. Yes, they want to know how you socialize with others. Yes, they want to know what are the tasks that you're usually trying to complete with these functions. And yes, the new season 2 of Andor is coming up, and we only have 30 minutes for the next video. So we're going to be ending this video immediately, because Star Wars. So with that said, please remember, this is a claim. I'm not doing it to scare you. I'm doing it to show you what's going on. Also, please hit the like button. Don't be shy. Give the like button a little waggle taggle right there. Come on now. Also, please remember to like, subscribe, head over to Google, type in Disability Resolution Law Firm or Disability Resolution Florida. Go ahead and throw some stars up there if you like. It's up to you. But the bottom line is I love waking up and seeing those. With that said, I will catch you all a little bit later. You have a wonderful, wonderful day. And remember, the next video I'm going to be doing, which I'm going to be doing about 5 minutes, is where I go live and answer questions for free to people who have them about disability law. Okay. Also, in the bio area below, if you need a private session with me for an hour, there's a little mini contract that you can use for me to figure out a disability situation that is particularly tricky. I will catch you all at the next video. Give me about 10 minutes, actually 5 minutes, and we will go from there. Attorney Walter Hnot, the most viewed and subscribed to disability attorney in America. We will rock and roll and catch up shortly from there. Thank you so much. Have fun, and I will see you soon. Thanks so much. Bye-bye, everybody. Bye-bye.